Hi, today's topic is confronting the cop, suicide or salvation. This is Bill Henshaw here again, Constitutional Crisis Channel, and this is not an easy question to answer. Over the decades, I've been pretty fortunate that I haven't had any serious run ins with a lot of these thugs. That probably comes in part, at least, from the fact that I know what I'm talking about, and I think even some of these goons recognize it right off. And I can deal with things like this. But even then, I make it a point, insofar as it's possible, not to get angry with any of them, because for the most part, they're not trained either, and they don't know what the damn law is and what the scope of their authority is. So remember this with most of your confrontations, with the cops, and I think things will go as well as can be expected. And of course, the cops are always notoriously famous for saying, "Tell it to the judge." Well, the problem with that is not only is there no judge to tell it to, there's no right to a trial by jury, at least if the Supreme Court is any authority on the subject, at least in a criminal misdemeanor case. Case is Blanton, Blanton versus Las Vegas, 489 U.S. 538. But the good news here is this gives us a lot of leverage when you file my 5 basic documents that are available in my document packets. And those of you that are interested in that, you can check in with me at my email, ccaspari@live.com, for more information on those packets of documents, which now come with a triple your money refund if you can prove me wrong on any of my unopposed issues. So that said, probably the less said during a traffic stop in particular, the better. Now, the cops are going to want you to produce certain information, and this is a key point in my recent jaywalking arrest, where I didn't have any ID. Hell, I haven't had any government issued ID for close to 30 years and don't need it, and I rescinded it all for cause. Fortunately, on that occasion, I was able to pull out of my pocket a copy of my birth certificate. And that did prove sufficient for this, and it was a flash decision that I made there, because if I got arrested and taken to jail for not having any government issued ID, that's the question I want to get to, and so should you. But weigh it very carefully, because I knew going in that I had a lot of important things to do, and if I'm sitting there in jail for any length of time, I can't do videos for you people on constitutional crisis. I won't be on talk show. My work is going to be slowed down with all my other people that are depending on me to be there for them, and some other considerations. So, flash decision, I decided under the circumstances not to do it. In any case, they're going to ask for things, and they may ask certain questions, and you can, at some point in time, just say, wait a minute, if you provided information and they can fill out their citation, that's all you need to say. And you say, fine, and you go ahead and sign the citation. A lot of people are going to disagree with that, but they're wrong. But before you sign it, you put in there CF, which is Latin for under duress and coercion. And that's now a factual situation for a jury to rule on, but it's never going to reach a jury, trust me. So you do that, make them happy, get the citation taken care of, and now you use my documents and getting my packets, and you send documents right down to the clerk of court the next day or two after this citation is issued. And the beauty of this is that the process, especially in California, takes so damn long that they probably won't even get the citation for 10 days to 2 weeks or longer, and yet you've already appeared before the clerk of court, and that's all you promised to do. Now they can't get you for a willful failure to appear. They can't prove it. This is how the law works, right or wrong, or good or bad. It's how it is in California, probably in your jurisdiction too. So for the most part, keep a cool head about you. And you know how bad some of these thugs can be these days. I mean, with the recent shooting of Stephen Clark up in Sacramento, they shot the kid 8 times in the back because they were afraid for their lives. Well, if I'm sitting on a jury, I call that second-degree murder, which is a video for another day. But nevertheless, keep it as cool as possible, because they don't know. And what we need to do is contact the people responsible for training them. And that's a food chain that sometimes is very hard to detect. What I do is, what I usually always do, is go to the root of the problem, because the governor, like in California, the territorial governor, Moonbeam, has the constitutionally mandated duty to see that the laws are faithfully executed. That's the top of the food chain. Your governor in your territory almost certainly has the same duty to perform under your constitution. And those are the ones who should be doing it. And it seems to me if they're not, this is the beauty of it, because we now go in there not with a civil rights action, but a common law action for trespass, be it armis, trover, assumption, things like that that you don't need statutes for, and for which the territorial governor will now be personally liable without any affirmative defenses and no immunity. Because if he's a territorial governor, and I can prove he is, guess what? He hasn't been appointed by the president. And that's required by Article 2, Section 2, Paragraph 2. Who the hell cares about the Bill of Rights when you have issues like this one? You go to all 6 articles of the Constitution, it's a treasure trove. And that's what it is I want to teach you. So you raise the right issues, the right status, the right court, case over. That's how simple it should be and was at common law in an earlier era, and that's what I want to get us back to today. Thank you.